Appeal in the matter of Unitel S.A. and Unitel International Holdings B.V. and Isabel dos Santos.
Yes. My lords, my lady, I appear on behalf of the appellant, Isabel dos Santos. With me are Mr. Olive Cooper and Mr. Martin Stamp. My own friends, Mr. Sinclair, King's Counsel, Mr. Knowles, appear for the respondent, Unitel S.A. Before I begin, may I check, please, that the court's received a core bundle, a supplementary bundle, a joint authorities bundle, and recently a supplementary authorities bundle?
We've got core, supplementary, 4 volumes, authorities and supplementary authorities, yes.
I'm very grateful. This is an appeal against 2 orders granted by Mr. Justice Bright on the 20th of December last year, a freezing order and an order that Mr. Santos should pay Unitel's costs of the freezing order application, which was made on notice. In respect to the freezing order, we say with respect that the learned judge was wrong to find that Unitel had a good arguable case, and that raises 2 questions. First, what's the meaning of the phrase good arguable case in this context? As we'll see, there's conflicting authority on that issue. Mr. Santos' position is that as a matter of authority and as a matter of principle, the phrase good arguable case should mean the same thing in the context of a freezing injunction as it does in the context of a jurisdiction challenge. That's to say, first, the claimant must demonstrate an evidential basis showing that it has the better of the argument. In deciding whether the claimant has done so, the court must seek to overcome evidential difficulties and arrive at a conclusion if it reliably can. But then the third limb, if, however, the court is simply unable to form a decided conclusion on the evidence before it, and is therefore unable to say who has the better of the argument, then the court may ask objectively whether the claimant has demonstrated a plausible, albeit contested, evidential basis for the claim. I'll refer to that as the Brownley interpretation after the decision of the Supreme Court in Brownley and 4 Seasons, in which that formulation was adopted. This is contested by Unitel, which says that the question is simply whether the claimant's case is more than barely capable of serious argument, and yet not necessarily one which the judge believes to have a better than 50% chance of success, and I'll call that the Niedersachsen interpretation. The second question in relation to good arguable case is whether, applying whatever the court considers the correct test to be, Unitel does have a good arguable case on the facts of this case, and that turns principally on whether Unitel has complied with Article 80 of the Angolan Law of Commercial Companies. However, Unitel has also raised an argument based on the doctrine of relation back under Section 35 of the Limitation Act 1980. Those issues will be addressed in due course by Mr. Olive Cooper.
Yeah.
In respect of the costs order, Mr. Santos' position is that the judge should have followed the usual practice on interlocutory injunctions generally, which is to reserve the cost to the trial judge. Unitel disputes that, and again, there's authority going both ways. In terms of the structure of our submissions, therefore, and subject, of course, to the court, first of all, I propose to run very quickly through the background to the judge's decision. I'll then deal with what's meant by good arguable case. Mr. Olive Cooper will then explain why Unitel doesn't have a good arguable case by reference to the evidence, whichever test is preferred. And then finally, I'll deal with the cost appeal. Dealing first of all then with the background, my lords, my lady, the background can be summarised quite shortly. Unitel is the state-owned telecoms company of Angola. Mr. Santos is a former director of Unitel. She's also the daughter of the former president of Angola and a highly successful businesswoman in her own right. As you may have seen from paragraphs 8 and 9 of our skeleton argument, it's her case that after being appointed as chair of Sonangol, Angola's state oil and gas company, in 2016, she discovered endemic fraud within that organisation. Her case is that the people responsible for that fraud included people close to Mr. João Lourenço, who in September 2017 replaced her father as president, and that in order to protect those individuals, the Angolan state has pursued a political campaign against her, which has included obtaining various freezing orders, either on its own part or via Unitel and Angola and Portugal. During her tenure as the director of Unitel, Unitel provided various loans to a company of which she was the legal owner, Unitel International Holdings B.V, or UIH, a Dutch company. Those loans haven't been repaid. Mr. Santos says this was ultimately because of steps taken by UIH and the Angolan government as part of the political campaign she says has been waged against her. which meant that UIH was unable to comply with its ostensible obligations under the relevant facilities. In October 2020, Unitel issued a claim against UIH pursuant to the loans. 2 years later, in October 2022, Unitel applied for permission to join Mr. Santos to that claim and to amend its statements of case to assert a claim against her. The nature of that claim is essentially that Mr. Santos breached her duties to Unitel under Angolan law by causing it to enter into the loans and associated security agreements, or causing it to do so on the terms of those documents, and by failing to enforce the agreements. The application for joinder was, save in relation to one of the proposed claims, a claim in unjust enrichment, granted by His Honour Judge Appellant King's Counsel in May 2023. And at the same time as seeking to join Mr. Santos to the proceedings, Unitel applied on notice for a worldwide freezing order. There was a hearing in November 2023 before Mr. Justice Bright. There was some debate between the parties at that hearing as to the correct interpretation of the phrase good arguable case. In December 2023, the learned judge granted a freezing injunction. He preferred Unitel's suggested interpretation of good arguable case, but held that Unitel satisfied the test on either view. There was then a consequentials hearing at which there was some discussion as to the principles applicable in respect of costs in these circumstances. Again, Mr. Justice Bright preferred Unitel's position and awarded Unitel its costs in any event. And in March this year, Lord Justice Arnold granted Mr. Santos permission to appeal. In terms of the test, good arguable case, if I may, I'm going to start by taking the court through the authorities so that we can see how the law has evolved. In my submission, what we will see is that there's only really ever been one test on the merits for a freezing injunction, which is the test set out in a case called Vitkovitsa. That test, however, has been interpreted in two different ways.
Sorry, in which case?
Vitkovitsa. I may be pronouncing it wrongly. It's a Czech case, but we'll.
Is that a corner case?
Corner, yes, exactly.
But that was a jurisdiction case.
That's right.
Yeah.
The test has been interpreted in two different ways, what I've called the Niedersachsen interpretation and what I'll call the Canada Water interpretation. And of those, we say that the Canada Water interpretation was authoritative, but there were difficulties with it. The first being that it set the bar too high, requiring the claimant to have much the better of the argument. The second was that it left unclear how the court should proceed in circumstances where it couldn't reliably determine which side had the better of the argument within the confines of the interlocutory process. And those issues are perhaps why, in many cases, judges continued simply to apply the Niedersachsen interpretation. But we say that in Brownley and Four Seasons, those issues were resolved in that the word much, as in much the better of the argument, was jettisoned, and the Supreme Court recognized that where it's not possible to reliably say who has the better of the argument, the court can apply an objective test. So we respectfully submit there's no longer, therefore, any reason why what now, as I call it, the Brownley interpretation, shouldn't be applied in the freezing injunction context, which is what the Court of Appeal did in a case called Lakatamia, and it's been endorsed in a number of first instance authorities. So if we could begin, please, by looking at, I'll call it corner. That's in tab 3 of the Joint Authorities bundle. Tab 3, beginning at page 14 of the bundle. The key issue is identified in the head note. RSC Order 11, Rule 1, provided that a summons could be served out of the jurisdiction when the action was brought in respect of a breach committed within the jurisdiction of a contract. To obtain leave to serve out, the test was that it should be made sufficiently to appear to the court or judge that the case is a proper one for service out of the jurisdiction under this order. That then raised the question of what made sufficiently to appear to the court or judge entailed. And on this, their lordships offered 3 answers, which the House of Lords in a subsequent case confirmed were intended to mean the same thing, as we'll see in due course. If I could ask you, my lord, my lady, to go first of all to page 24. In the final paragraph on that page, one sees Lord Simmons saying, it is no doubt difficult to say precisely what test must be passed for an applicant to make it sufficiently appear that the case is a proper one. I do not wholly like the expression a prima facie case, for where leave to serve out has been given ex parte under Order 11, and application is then made under Order 12 to set the proceedings aside, a conflict may arise in which the question is not so much whether a prima facie case has been made out, as whether upon all the materials then before him, the judge is of opinion that the case, I can find no better word, is a proper one to be heard in our courts. The description of good arguable case has been suggested, and I do not quarrel with it. But for the purpose of this appeal, it's sufficient to say negatively that the learned judge fell into error in thinking that the court had no jurisdiction to grant leave because he was not quite satisfied that there had been a breach within the jurisdiction. So this is where the expression good arguable case is ultimately derived from. If one then goes forward, please, to page 28 in the speech of Lord Radcliffe, the second paragraph on that page, Lord Radcliffe says the last direction contained in Rule 4 is in form of prohibition. No such leave shall be granted unless it shall be made sufficiently to appear to the court or judge that the case is a proper one for service out of the jurisdiction under this order. But I suggest to your lordships that it's from these words and these words alone that it's possible to ascertain what measure of proof the judge should require before deciding that he's authorised to make an order under this procedure. It must sufficiently appear to him that it is a proper case. The phrase is a composite one, and it's not elucidated by taking it to pieces, but it seems to me clear that the use of the word sufficient in this context shows that it's not necessary that the judge should be satisfied beyond reasonable doubt as to the existence of the qualifying conditions. Further, a case does not sufficiently appear to be a proper case for the purposes of this order unless on consideration of all admissible material there remains a strong argument for the opinion that the qualifying conditions are indeed satisfied. If one turns over the page to page 29 of the bundle, the first new paragraph towards the top of that page, Lord Radcliffe went on to say, the other criticism is that a prima facie case puts the standard of proof somewhat too low, while to be satisfied puts it somewhat too high. These are, of course, only words, and I do not wish to chop their meaning over fine, but I prefer the test of a strong case for argument that I have just suggested. And then if one goes, please, to page 35 in the authorities bundle, one sees that in his speech, Lord Tucker said, this is in the second paragraph, fourth line of that paragraph on page 35, the judge was not concerned to inquire closely to ascertain all the terms of these contracts or whether or not the defendants might have a sufficient set-off to extinguish their alleged indebtedness thereunder. But he was, as I think, concerned to inquire and to satisfy himself that the probabilities of the case were strongly in favour of the plaintiff's contention that the contracts contained a term providing for payment in England. Just pausing there, we say that properly understood, what Lord Tucker is making explicit there is what was perhaps implicit in the other speeches that we've looked at, which is that a good arguable case involves having an argument that on the evidence available is better than the other side's argument. The probability of the case was strongly in favour of the plaintiff's contention. And then just above the start of the final paragraph on that page, 4 or 5 lines up from there, he went on to say, made sufficiently to appear is an awkward expression which can, I think, be conveniently and accurately expressed as satisfied without it being thought that he thereby meant that it had to be proved as issues require to be proved at a trial. So, as I say, that case is the ultimate origin of the expression good arguable case.
And it's addressed to the gateway. It's not addressed to a merits threshold in relation to the merits of the claim.
That's right, and this is a point which is picked up in some of the other cases as we'll see. In the jurisdiction context, good arguable case remains the test in relation to gateways rather than in relation to merits. That's a point I'll come back to, but we'll see that picked up in some of the other cases. If we can go next, please, to a case called the Pertamina. That's at tab 6, beginning at page 45 of the authorities bundle. And it's an obvious point, but worth keeping in mind. This was one of the early freezing injunction cases decided, I think, slightly less than 2 years after the Morava itself had been decided. And in fact, it was an application, an appeal rather, against the discharge of a freezing injunction. And if one looks at the head note, it records just above E on page 45, on the plaintiff's application to continue the injunction, the judge discharged it on the grounds that the plaintiffs would not be successful if they applied for summary judgment under Order 14. One of the questions before the Court of Appeal was whether that was the right test to apply. And if I could ask you, my Lord, my Lady, to go to page 62, round about D in the middle of the page, there's a subheading, the application of the new procedure. And Lord Denning, the Master of the Rolls, said this. Now, for the application of this new procedure, it must be noticed, however, that in those 2 cases, the injunctions were only granted so as to hold the position until the defendants were heard. As it happened, they never did ask to be heard, no doubt because they had no defence. The cases were ones in which summary judgment would have been given under Order 14, but in the present case, the defendants Pertamina have come in to be heard. They say that they have a good defence, or at any rate, a defence which is plainly arguable, and they say on that account no injunction should be granted. I would not myself limit the discretion of the court to cases so plain that the plaintiff can get judgment under Order 14. We've all had experience of summonses under Order 14. The defendant may put in an affidavit putting forward a specious defence sufficient to get him leave to defend, conditional or unconditional. But when the case actually comes to the court for trial, he throws his hand in. It's then seen that the affidavit was simply filed in order to gain time. So under this new procedure, a defendant may put forward a specious defence just so as to remove his assets from the jurisdiction. The weakness of the defence may not appear until later. And so then he says, so I would hold that an order restraining removal of assets can be made whenever the plaintiff can show that he has a good arguable case. That's a test applied for service on a defendant out of the jurisdiction, see Vitkovitzer and Corner. And it's a good test in this procedure, which is appropriate when defendants are out of the jurisdiction. It's also in conformity with the test as to the granting of injunctions whenever it's just and convenient, as laid down by the House of Lords in American cyanamid. So just picking up a couple of points there. First of all, the mischief that the Master of the Rolls was trying to avoid was a situation in which a defendant could avoid an injunction being granted simply by putting in a specious defence. We say that there's obviously some distance between that situation and the current position, if that is the Niedersachsen interpretation is applied, whereby if a defendant wants to avoid a freezing injunction, he has to put in evidence which shows that the claimant's claim is not even capable of serious argument. Secondly, we respectfully submit it shows that from the very outset, the good arguable case test was intended to be the same in the freezing injunction context as it was in the jurisdiction context from which it had been borrowed.
What about the last sentence? It's also in conformity with the test in cyanamid injunctions.
Well, there are two criticisms which I will come back to that can be made of that passage. One is that we're not concerned in a freezing injunction context with a simple cyanamid balance of convenience. I accept that. The other is that, of course, things have moved on from where Lord Denning, the Master of the Rolls, seems to have had in mind that freezing injunctions would be made when defendants are out of the jurisdiction. Of course, that's no longer a condition for making a freezing order either. But one does see, in my respectful submission, that it's at this stage that good arguable case is borrowed from the jurisdictional context into the freezing injunction context.
But in the context in which Lord Denning at least thought it meant the same as the merits test in cyanamide.
Well, with respect, I'm not quite sure that's what he's saying. He says it's in conformity with the test as to the granting of injunctions whenever it's just and convenient. I'm not sure that he's saying that just and convenient is to be equated with good arguable case in terms of an assessment of the merits.
What is he saying about conformity with cyanamide then? I mean, he's addressing a merits test. On the one hand, he said it's the test on jurisdiction in Bitkovici and a good test when defendants are out of jurisdiction, but then he also says it conforms with the test in cyanamide.
Well,
They are different, aren't they?
What he may have been getting at is that, as in an American cyanamide context, one isn't required to prove a case on a balance of probabilities in the way that one would be at trial. I'm not sure, he talks about being conformity, but I'm not sure that he's saying that these are precisely the same things. But I accept, as I say, I'll come back to it, I accept that there are some difficulties in understanding completely exactly what the Master of the Rolls was getting at in that passage.
But it's early days anyway in the development of the
Very early days,
jurisprudence on
very early days, and indeed it's the stage at which, for the first time, good arguable case was alighted upon as being the appropriate merits test in a freezing injunction context. But one sees how that came about. One then comes to the Niedersachs, and that's at tab 8, page 74 of the Joint Authorities bundle. And this was in 1983. So this was an application to discharge a moreover injunction. If one goes to page 78, after noting, and this is page 77 at J, that the principles applicable to moreover injunctions were still uncertain, Mr. Justice Mustill identified two questions. The first was, what probability of success at the ultimate trial is the plaintiff required to demonstrate before an injunction can be properly granted or maintained? And if one goes to page 79, he refers there at the top of the page to the Pertamina case, which we've just seen, which he describes as the foundation authority. That's at G. The judge took issue with Lord Denning's reference to American cyanamide, noting correctly that good arguable case isn't the test applied in the American cyanamide context, and he also took issue with the analogy with jurisdiction challenges, not least because by that stage freezing injunctions were being granted against people outside, within the jurisdiction. So those are the 2 points which I flagged a moment ago as issues with what Lord Denning had said. But he noted that the test had been adopted in another Court of Appeal decision, and so he suggested that the test should still be applied. This is at G. It seems appropriate to adopt it here, but what exactly does the expression mean? And the answer to that, he said, was to be found in Corner. It says the case isn't easy to analyse, but that the following propositions appear to be justified, and he sets out a numbered propositions. Looking at 4 at J, nor does the expression made sufficiently to appear mean that the court should apply the same standard of proof as will be appropriate at the trial, for reasons which must have been special to the situation in Corner, but which not appear from the report. 2 of the speeches refer to proof beyond reasonable doubt. Presumably in an ordinary case, the proposition implies that the plaintiff need not establish his case on balance of probability. With no difficulty with that. He then goes on to saying 5, leaving aside the speech of Lord Oaksey, who appears on this particular issue to have been in a minority, the speeches use a variety of terms to express the same concept: satisfied, a proper one to be heard in our courts, a good arguable case, a strong argument, a strong case for argument. these expressions suggest that the plaintiff has to do substantially more than show that the case is merely arguable, a word which to my mind at least connotes that although the claim will not be laughed out of court, the plaintiff will not be justified in feeling any optimism. On the other hand, if I'm right on proposition 4, the plaintiff need not go so far as to persuade the judge that he's likely to win. Pausing there, this, we respectfully submit, is where Mr. Justice Mustell fell into error, in that he seems to have formed the view that requiring the claimant to show that it's likely to win is tantamount to requiring it to prove its case on the balance of probabilities. But we say with respect that's not right. And this error then feeds into his conclusion, and this is at D on page 80, that in these circumstances I consider that the right course is to adopt the test of good arguable case, in the sense of a case which is more than barely capable of serious argument, and yet not necessarily one which the judge believes to have a better than 50% chance of success. And the problem with that formulation, our respectful submission, is that it misses out entirely any requirement for a relative assessment of the merits of each party's case, as we say was endorsed by the House of Lords most clearly in Lord Tucker's speech in Corner, and in the cases that have interpreted it since. Now that case then went on appeal to this court, which endorsed the good arguable case test, but didn't actually get into whether Mr. Justice Mustell's exposition of what that entailed was right. If one goes to page 90, so this is now in the report of the Court of Appeals decision, at J, bottom of the page, one sees Lord Justice Kerr saying, it's convenient to pause at this point, since that's all that needs to be said by way of summarising the evidence on the first question posed by the judge. Having referred to a number of the authorities, he answered this by saying, in effect, have the plaintiffs, the buyers, shown that they have a good arguable case? He took this test from the judgment of Lord Denning, the Master of the Rolls, in the Pertamina, and pointed out that this test was followed by this court in Ferry Jones. Although other and perhaps slightly stronger words have been used in other cases, the sellers didn't challenge this formulation of the present appeal. We respectfully agree with it. So what Mr. Justice Mustell had said was endorsed by the Court of Appeal in those terms, but they didn't go into his exposition or explication of the good arguable case test. While we're on page 91, perhaps I could just mention in passing what's said at D. A good arguable case is no doubt the minimum which the plaintiff must show in order to cross what the judge rightly described as the threshold for the exercise of the jurisdiction. But at the end of the day, the court must consider the evidence as a whole in deciding whether or not to exercise this statutory jurisdiction. The next key case is Canada.
Before you leave, that's the Court of Appeal endorsing what Mr. Justice Mustell had also said at the top of page 403, that the merits come in at 2 stages. There's a threshold, and then they are to be weighed in the balance with other factors, rather than the exercise of discretion.
My lord, yes.
Could you just explain to me how they come in at the 2nd stage, if they still do?
I think our submission would be that in practice they don't seem to, which is why a focus on exactly what's meant by good arguable case is so important in the merits stage, because once that threshold is passed, one's experience is not that courts then factor merits back in again at a subsequent discretionary stage. That's what Mr. Justice Mustell had in mind. That was endorsed by the Court of Appeal. But if this is an answer to your Lordship's question,
And has anyone ever said they were wrong about that in terms?
not that springs to mind, my Lord, no.
And one can see that the merits are relevant to the test of real risk of disposal in cases which typically involve allegations of fraud as part of the cause of action. And certainly in the cyanamide context, in certain circumstances, the merits test are treated as coming merits are treated as coming back in at the balance of convenience stage or the balance of prejudice stage, typically, for example, where the interim injunction is likely to be dispositive. So that they do come in there. Do you say no room for them to come in relation to just and convenient in a freezing order context?
I don't put it like that, my lord, but I say that in practice that doesn't seem to happen. Once a party has got over the merits threshold, it's rare in my submission that there's further reference to merits in the context of discretion in the freezing order context.
Thank you.
So Canada Trust, that's at tab 12 of the authority bundle. This was a jurisdiction challenge case. One can note Lord Justice Waller saying, page 155 at C, we've had a full and helpful citation of the authority. If one goes to the bottom of that page, we see that he reproduces quite a lengthy extract from Lord Gough's speech in the Seekensar case, which makes an important point about the speeches in Corner. If one goes over to page 156 at B, one sees it said that Lord Simmons, with whom Lord Normand agreed, said that the description of a good arguable case has been suggested by counsel for the plaintiff, and I do not quarrel with it. And Lord Radcliffe, with whose statement of principle Lord Tucker agreed, used the expression a strong argument and a strong case for argument. There's no reason to suppose that there's any material difference between these various expressions, from which is derived the good arguable case test, which was applied in innumerable cases since. And the reason I mention that is to eliminate any suspicion that Lord Tucker's, we say explicitly relative statement of the test, might have been an outlier, with the rest of their lordships in Corner having endorsed, it might be said, a purely objective test. There's no material difference identified between the various formulations that we used in that earlier case. And if we can then go, please, to page 157, at F and G, there's a key passage where Lord Justice Waller said, it's also right to remember that the good arguable case test, although obviously applicable to the ex parte stage, becomes of most significance at the inter partes stage where two arguments are being weighed in the interlocutory context, which, as I've stressed, must not become a trial. Good arguable case reflects in that context that one side has a much better argument on the material available. It's the concept which the phrase reflects on which it's important to concentrate, i.e. of the court being satisfied or as satisfied as it can be, having regard to the limitations which an interlocutory process imposes, that factors exist which allow the court to take jurisdiction. And that test was subsequently endorsed by the Privy Council in two jurisdiction cases. I'm not going to ask your lordships and your lady to look at them, but for your note, they're Bowles Distilleries, which is at tab 16, specifically at paragraphs 26 to 28, and Altimo Holdings at tab 19 at paragraph 71. So when Canada Trust was decided, it was the authoritative statement of the meaning of the phrase good arguable case. Unsurprisingly, given that the phrase was, we say, supposed to have a consistent meaning across jurisdiction and freezing injunction context, it was then adopted in the freezing injunction context, and there are three examples in the bundle. The first is Petroleum Investment and Counterpan Holdings, that's at tab 15. And if one goes, please, to page 199, one sees the reference to the expression good arguable case having been used in Corner in the context of an application to serve out, adopted in the Moravian jurisdiction by Mr. Justice Mustill, and its meaning has been considered in a number of later cases, including Seekensar, Rowland, and Canada Trust. And then if one goes to the bottom of the page, after referring to Canada Trust, Justice Toulson said in paragraph 37, I'd fasten on the last few words of that passage about the need to be satisfied having regard to the limitations inherent in the interlocutory process, that factors exist allowing the court to take jurisdiction. Lord Justice Waller was speaking in the context of an application to serve out. The same concept is equally helpful when considering whether to make a freezing order. And then at 38, at the top of page 200, the limitations inherent in the interlocutory process may vary from case to case according to the subject matter. Where the subject matter involves questions of fact on which the evidence is incomplete and contradictory, it may be very difficult for a court to form even a preliminary view as to the parties' rival strengths. Reading Lord Justice Waller's judgment as a whole, I don't understand him to be suggesting that in such a case the court has to be satisfied that the evidence on the claimant's side is stronger than the evidence on the defendant's side in order for the claimant to make out a good argument case. For that would be in effect to apply the civil standard of proof, which he emphasises not applicable at the interlocutory stage. However, where the claim depends on the construction of a contractual document on which there's detailed argument at the inter-party stage, the court may well reach a conclusion that one side has a much better argument than the other, although it must remember that the ultimate decision would belong to the court of trial or arbitral tribunal. And as we'll see, this is basically the approach that would later be endorsed by the Supreme Court in Brownley and Four Seasons in the jurisdiction context. The second of the cases where in the freezing...
You said this was a case in which Canada Trust was adopted in freezing order context, but I'm not sure that is what Mr. Justice Toulson is saying at 38, certainly in a case where there's a factual dispute. He's saying you can't tell who's got much better of the arguments where there's a factual dispute, and that's a limitation in applying it. None of this may matter very much because, as we know, that aspect has now gone. Much has gone, and that's.
I mean, we say with respect that he clearly is taking Canada Trust as it seems the last words, simply the last word in terms of the cases identified in paragraph 34, as to the meaning of good arguable case. He certainly doesn't express in 37 or 38 any disagreement with what Lord Justice Waller had said, but he explains how he understands Lord Justice Waller's judgment should be understood, which is to say that one certainly doesn't apply the civil standard of proof, but that there may be circumstances in which it's very clear which side has, as it was then formulated, a much better argument than the other.
But at least you say he's taking the approach that the appropriate test for gateway and jurisdiction cases is an appropriate test for the purposes of the merits of a freezing.
One interpretation of his judgment, picking up my lord's point, the point that he's making about the difficulty of determining whose evidence is stronger is really the point that subsequently becomes limb 3 of the Brownley test, whereas the other bit, the last couple of sentences, is really limbs 1 and 2 of the Brownley test, where it's much easier to determine who's got the better of the argument, leaving much out of account for that.
My lord, yes, and when you
So,
can't
I think
do that,
it's just an early
adumbration.
attempt to formulate the test.
But it's certainly, if I may respectfully say so, it's certainly consistent with what is now the Brownley test, or as I call it, the Brownley interpretation. Sorry, I think I was going to ask you next, if I may, to go to tab 18, which is the judgment of Mr. Justice Roth in the Complete Retreats Liquidating Trust and Logue. And if I could ask you please to go to page 284. There's a reference in paragraph 71 to Canada Trust, And then the learned judge said in 72, that case concerned the test for service out of the jurisdiction, but there seems no basis not to apply that observation in the context of a freezing order, while recognising that this does not, as it were, import the ordinary civil standard of proof by the back door. And then the third of these cases is at tab 21, which is in in my copy, is the second authorities volume.
Yeah.
And this is a case called TNK BP Holding. If one goes to page 350, one sees that the learned deputy judge says in paragraph 80, in the context of a freezing injunction, I bear in mind the threshold test which holding is required to satisfy at this stage, good arguable case. And the judge makes the point that the test of more than capable of barely serious argument is the minimum which the claimant might require. And in paragraph 82, he refers to complete retreats, which we've just seen. And over the page on 351, in paragraph 83, he says that the result of the test, as formulated in the Niedersachsen, is that a relatively low merits threshold applies to trigger the jurisdiction to grant a freezing injunction. However, the court will, in determining whether or not to exercise or continue the exercise of that jurisdiction, have regard to the strength of the case more generally when exercising its discretion. So this picks up on my Lord's point. We say that it's relatively rare that one sees in practice merits coming back in explicitly in consideration of discretion in the freezing injunction context, but the learned deputy judge there certainly contemplated that that was part of the process. Then he went on to say, I respectfully agree with Mr. Justice Roth. There's no material difference between the test to be applied for the grant or continuation of a freezing order on the one hand and for service out of the jurisdiction on the other. In each case, I propose to consider the evidence as a whole in order to determine whether I'm satisfied or as satisfied as I can be at this stage that holding has a much better argument than the applicants and Mr. Telsa. I should at this stage, I think, address a case that's relied upon by the learned friends. If one goes back, please, to the first authorities bundle at tab 20, one finds a case called Nakasamia Shipping and Nobu Su Limited. I'm going to call it Su 2012. There are quite a few Lakatamia and Su decisions, and I see that Lakatamia and Su is in court 27 today, so maybe there will be more. But this is the Court of Appeals decision in what I'll call Su 2012. If I could ask you please to go to page 328, paragraph 12, one sees the court referring to the Pertamina and the Niedersachsen, and referring to what I've described as the Niedersachsen interpretation in paragraph 25 at the bottom of page 330 and the top of page 331. But it's not clear that Canada Water or any of the freezing injunction cases that followed Canada Water, such as petroleum, Canada Trust, forgive me.
Canada Water is a tube station.
Any of the cases that followed it, such as complete retreats or petroleum investments, was even cited to the Court of Appeal. So to the extent that it sought to rely on that case as some sort of rejection of the Canada Trust interpretation in the freezing injunction context, we say that there's no basis for supposing that that was the case. Can we then briefly look at another case that's relied upon by the learned friends? This is, I'm afraid, back in the second authorities volume at tab 22, Kazakhstan Kakazi.
So are you saying that this was decided per incuria? This is a Court of Appeal decision saying the test is that identified by Mr. Justice Mustle in the Niedersachsen.
We
Is
do,
it right-
we
is it
do,
binding on us?
with respect, we say it isn't because Canada Trust appears not to have been cited and wasn't referred to, and that was a House of Lords authority on the question of what's meant by good arguable case.
But it's a
Jurisdiction.
But I accept that it's a jurisdiction case, but if we're right in saying that as one sees through the evolution of the case law, that the good arguable case test was always intended from the outset to be applied in the same way in the jurisdiction context and the freezing order context, then the fact that it appears not to have been cited at all would, in my submission, mean that binding House of Lords authority was simply not taken into account in that case.
Can I just pick up a very small point? In paragraph 12 of Lord Justice Longmore's judgment, he refers to the report of Mr. Justice Mustle's judgment in the Lloyd's reports, and that's of some importance. Is somebody checked that? Because I noticed the one that's in the bundle is from the All England reports, not the Lloyd's reports. And I seem to remember that Niedersachsen is one of those cases where there's more than one version of the judgment floating around.
It's the same.
Mr. Sinclair's Junior may know the answer. It may not matter, but Lord Justice Longmore seems to have been drawing a distinction between the Lloyd's report and the weekly report.
I'm not sure that there is a difference. I think
Yes, I understand that the text is the same, but I think one of the reports has both first instance and the Court of Appeal decisions, and that's the one we've included.
Yeah, that's the one that's in just
Yes, All England has both reports, that's why that's the one in the bundle. And so does Lloyd's. But as I understand it, my learned junior informs me the text of the judgments are the same.
I mean, yeah, thank you. And you're perfectly entitled, Mr. Margin, to say, well, none of these, insofar as these cases, including Sue, say, well, the test is the Niedersachsen test, and they don't cite Canada Trust. Yeah, I don't know whether they did or didn't. That's the trouble, because we don't have a law report. But what the judge says at paragraph 12 about what commercial court judges did and do is entirely accurate, speaking as somebody who was a commercial court judge in 2012. We applied the Niedersachsen test, and I don't ever remember anybody suggesting that we should apply the Canada Trust test. So for years on your case, commercial court judges applied the wrong test per incuriam, and presumably chancery judges did likewise. But anyway, there we are.
I think it might also be said that one would expect Lord Justice Longmore to have been pretty familiar with the test in the jurisdiction context as it developed both in practice and sitting as a first instance commercial judge and judging commercial appeals. So the idea that he decided this without knowing that the test in jurisdiction cases was the Canada Trust test strikes me as a little unrealistic.
I think perhaps the best I can say on that is we have provided some examples of the Canada Trust test being applied in a freezing injunction context. I'm not in a position to say how many more there are that do or don't, but one can see that those are some instances where clearly Canada Trust was cited and applied by judges in a freezing order context. Sorry, I think I was about to invite you, my lord, to go to Kazakhstan. That's tab 22.
Tab 22.
So this was an appeal in respect of an application to discharge a freezing order granted on a with notice application. One sees from page 428, paragraph 21, reference to paragraph 64 of His Honour Judge Mackey, Queen's Counsel's decision. Between F and G, the judge directed himself, I still have to consider whether the claimants have a much better argument on the material currently available. So that's another instance of, in practice, a first instance judge asking himself the Canada Trust question. And it's important, my respect for submission, to keep in mind that neither party sought to argue on the appeal that the judge at first instance had been wrong to apply Canada Trust. And so all the observations that follow in this case were made without the benefit of argument on that issue. When, with respect, my learned friends say in their skeleton argument of paragraph 48.3, that if the solution was just to drop the word much and otherwise to adopt Canada Trust, the Court of Appeal would have done so in this case. In our respect for submission, that's unrealistic because the court wasn't being asked in this case to refine the test in that way.
But the point about this case, surely, and the reason why it's relied upon, is what Lord Justice Longmore says in paragraph 25, where he says, in terms, that Judge Mackey set the bar too high by referring to much the better argument.
Well, no doubt it is relied upon for that purpose, but it's also important, in my respect for submission, to keep in mind exactly what Lord Justice Longmore said. Paragraph 25, KK had a much better argument. I would with respect, say that this sets the hurdle a little too high. Refers to pertamina, good arguable case, not referring to any authority which has changed that test. Much the better of the arguments recently emerged as a test on application service out, but he didn't see why that should be the same in freezing orders. And then he goes on at the end of that paragraph to say the fact that the judge may have applied a slightly higher hurdle than he need have done doesn't in any way affect his conclusion. So we say that in practice, the observations made by Lord Justice Longmore there in relation to much the better of the argument can be regarded as disposed of when one sees the subsequent refinement of the Canada Trust test, the jettisoning of the word much, and the interpretation which we now have from the Supreme Court in Brownley. So the fact is that much the better argument was in Lord Justice Longmore's view only slightly too high. I should of course mention what Lord Justice Elias said at page 439 as well.
But does it go a bit beyond that? Because he's explicitly recognising that the testing should not be the same in a jurisdiction case.
Well, my lady, he does say that, but he says that, as I have explained, without this being a point that either party was taking on the appeal. So with all due respect to Lord Justice Longmore, a very experienced commercial judge, as has been observed today, these statements were made without the benefit of argument on the point.
But at some stage you're going to explain to us what the answer is to Lord Justice Longmore's point. In other words, why should you apply a gateway jurisdiction test to the merits test for a freezing order?
My lord, I will. Could I, perhaps the quickest way of doing this, could I just draw to your attention, my lords, my lady, paragraphs 66 to 68, paragraphs 439 to 440, where Lord Justice Elias expressed his agreement with what Lord Justice Longmore had said, and observed that in his view that the policy considerations were different in the two situations. It's it's correct that in jurisdiction cases, the merits threshold is serious issue to be tried, but there are occasions where in order to determine whether a jurisdictional gateway is applicable, the court has to consider matters that will be assessed at trial, merits issues, and in those circumstances, the court does apply the good arguable case threshold. So it's not the case that good arguable case is never applied in relation to merits issues in the jurisdiction context. And that's a point, just for your note, that's made in Canada Trust at pages 157.
Sorry, could you just
C
say that
and
again?
F.
I hadn't quite followed what you were saying. If you could just repeat the submission.
Yes, that whilst in jurisdiction cases the merits threshold is serious issue to be tried, there are occasions when, in order to determine whether a jurisdictional gateway is applicable, the court has to consider merits issues that will be considered at trial. And in those circumstances, the court does apply the good arguable case threshold. So it's not the case that good arguable case is never applied in relation to merits issues in the jurisdiction context, and that's a point
It's only
taken
applied
up in.
because it has to be satisfied for gateway purposes, not because it has to be satisfied looking at how strong a case the claimant has.
I accept that.
And that you said that was mentioned in Canada Trust?
It is at pages 157 at C and E to F. And the final paragraph that I was respectfully drawing to the court's attention in Lord Justice Elias's judgment was paragraph 68 on page 440, where he says there is therefore reason to suppose that the judge applied too stringent a test. However, we heard no argument on the point, and it wouldn't be right to express a concluded view on it. So there's no question that Lord Justice Elias was doubting that the test should be the same in the freezing injunction context as in the jurisdiction context. But again, that was in circumstances where the Canada Trust test required much the better of the argument, and Lord Justice Longmore's views were expressed, in my respect for submission, in a provisional and slightly tentative way. The judge may have been putting the case too high. I doubt whether he was right to follow the jurisdiction cases, and as one sees from Lord Justice Elias's judgment, all of this was without the benefit of argument. Can we then go, please, to the next tab? I'm going to call this Sue 2014. It's Lakatamia and Sue, Court of Appeal 2014. One sees the issue on the appeal identified in paragraph 1 at the bottom of page 444. And if one then takes it up on page 456, Lord Justice Tomlinson's referring there, paragraph 32, to a summary of the Cabra jurisdiction given in C. Ukraiński Akcjonalny Bank. The test of good reason to suppose is to be equated with good arguable case, that's to say one which is more than barely capable of serious argument, but yet not necessarily one which the judge believes to have a better than 50% chance of success. In my respect for submission, this can't realistically be taken to be the Court of Appeal endorsing the Niedersachsen interpretation and rejecting Canada Trust, because that wasn't the question on appeal. This wasn't even a Cabra case. So the discussion, in my respect for submission, at page 456 doesn't really take matters further forward.
Well, it's an express approval, isn't it, of the one which my lord summarised the jurisdiction in that Maximov case.
Well, in relation to the exercise, forgive me, my
And it
lord.
may be the Chabra jurisdiction, but it's a species of freezing. And the second point is saying two things, isn't it? Good reasons to suppose is to be equated with good arguable case. That's one thing. And then it's saying good arguable case, the test is the Niedersachsen test. And true it is that Lord Justice Tomlinson doesn't mention the Niedersachsen, but that's clearly what he's formulating. I'm sorry, Mr. Justice Popplewell doesn't mention it. But this is an adoption by the Court of Appeal of my Lord's judgment.
Well, with respect, it's a quotation from my Lord Justice Popplewell's summary of the Cabra jurisdiction in that case, in circumstances where there was no debate in this case as to what the applicable test was, and indeed it wasn't a Cabra jurisdiction case. So my respectful submission is this can't be taken as an endorsement of Niedersachsen in the sense of a rejection of Canada Trust. If I could ask you please to go to Hollyoak and Candy, which is behind tab 26.
Yeah.
Starts at page 489. This was an application of what's now known as a notification injunction. The defendant submitted that good arguable case meant the same thing in the jurisdiction context as in the freezing order context. The claimant disagreed, so that question was directed before the court. And Mr. Justice Nugee endorsed the position set out in Petroleum Investments. So if one goes to page 504, one sees beginning at paragraph 11, there's a survey of the authorities taken from the very earliest days of the freezing order jurisdiction. And then one sees top of paragraph 13, that leads Mr. McQuaid to submit the same applies in an application for a freezing injunction. There's a reference to some of the cases that we've looked at. And then there's the passage of paragraph 38 of Mr. Justice Toulson's judgment of Petroleum Investment, which we looked at earlier. And Mr. Justice Nugee says, this is just below F, that I must confess chimes with my own instinctive inclination. When the question is one of construction or one of law, and there's argument on the point, the court may well be able to take a view as to who appears, albeit at the interlocutory stage, to have the better, or indeed much the better of the argument. Where, however, the merits of the case turn on questions of fact, it would impose a severe limitation on the court's ability to grant effective relief if it had to be satisfied that the claimant had much the better of the factual case. That's very often impossible to say at the interlocutory stage, where the issues are pure factual issues, particularly if the question turns on the credibility of witnesses. Then, from paragraph 14, Mr. Justice Nugee referred to the Kazakhstan case, which we've been looking at. His conclusion, as one sees from paragraph 15 on page 506, was that the views expressed in that judgment were consistent with the views expressed in Petroleum Investments and his own instincts. And so he says, para 15, in the case of purely factual questions, I consider that it's sufficient for the claimant to meet the traditional test laid down by Mr. Justice Mustel in the Lilelia Maritime Corporation case. But that endorsement of what I've called the Niedersachsen interpretation was therefore confined to purely factual questions, and he didn't discount a relative assessment when it came to matters of construction or questions of law. In other words, where the court can form a reliable view on the merits in terms of the first two limbs of Brownley. I should say that that case, Hollyoak, went on appeal to this court, but not on the question of good arguable case, on the question of real risk of dissipation. We come then to Brownley, that's at tab 27, which of course was a jurisdiction case. At 568, Lord Sumption addresses the evidential standard with a review of the authorities from that corner, Seek&Sa and Canada Trust. One sees on page 569, para 7, it talks about an attempt to clarify the practical implications of these principles being made in Canada Trust, and refers to what Lord Justice Waller had said about a much better argument than material available, the court being satisfied or as satisfied as it can be, having regard to the limitations which an interlocutory process imposes, that factors exist which allow the court to take jurisdiction. He talks about what then happened in terms of the approval in general terms by Lord Steyne, with whom Lord Cook and Lord Hope agreed, but without full argument. then referred to the fact that it had been specifically approved twice in the Privy Council, those cases for which I gave you the reference, and then says, in my opinion, it's a serviceable test provided that it's correctly understood. The reference to a much better argument in the material available is not a reversion to the civil burden of proof, which the House of Lords had rejected in Vicrovitz. What's meant is, one, that the claimant must supply a plausible evidential basis for the application of a relevant jurisdictional gateway. Two, that if there's an issue of fact about it or some other reason for doubting whether it applies, the court must take a view on the material available if it can reliably do so. But three, the nature of the issue and the limitations of the material available at the interlocutory stage may be such that no reliable assessment can be made, in which case there is a good arguable case for the application of the gateway. If there is a plausible, albeit contested, evidential basis for it, I do not believe that anything is gained by the word much, which suggests a superior standard of conviction that's both uncertain and unwarranted in the context. I won't take you there, but Baroness Hale agreed with that, paragraph 33 on page 581, and so did Lord Wilson, paragraph 56 on page 587. And that test was endorsed again by the Supreme Court in Goldman Sachs. I'll give you the reference at paragraph 9, page 597, Lord Sumption again, with whom the other members of the court agreed. And any issue about what was said in Brownley having possibly been overturned evaporates because of the express adoption or endorsement in Goldman Sachs and Novel Banku. Despite that clarification, there was still some uncertainty as to whether what the Supreme Court had in mind was a relative test or an absolute test, and the significance of that was summarised by Lord Justice Green in Kafer. That's at tab 29, and the relevant passage is on page 622. Having referred in paragraph 60 to Brownley and Goldman Sachs, in paragraph 61, Lord Justice Green said, before addressing those authorities, it's sensible to provide a word of explanation about the key conceptual dispute between the parties. This concerned the asserted difference between an absolute test and a relative test. It's argued that an absolute test is one where the claimant, if found jurisdiction, need only surmount a specified evidential threshold that doesn't involve the court otherwise assessing the relative merits of the competing arguments. In contrast, it's argued that a relative test does involve the court in looking at the merits in a relative sense to see whose arguments are stronger. And the Court of Appeal then took the opportunity to express how Brownley should be applied in practice. If one goes to page 626, paragraph 73, Lord Justice Green says it's, in my view, clear that at least in part the Supreme Court confirmed the relative test in Canada Trust. That's plain from the express endorsement in Brownley, and nothing in Goldman Sachs detracts from that analysis. Reference to a plausible evidential basis in one is hence a reference to an evidential basis showing that the claimant has the better argument.
Sorry, where are you reading from?
From paragraph 73, forgive me, at E on page 626. If time permits in due course, I respectfully ask the court to read the whole of this section, but if I just pick up the key passages, paragraph 77, page 627 at B, the adjunct much in the Canada Trust formulation must be laid to rest. A plausible case is not one where the claimant has to show it has much the better argument. Lim 2, paragraph 78, Lim 2 is an instruction to the court to seek to overcome evidential difficulties and arrive at a conclusion if it reliably can. It's an instruction to use judicial common sense and pragmatism, not least because the exercise is intended to be one conducted with due dispatch and without hearing oral evidence. Paragraph 79, the relative test has been endorsed in part because Lim 3 is intended to address an issue which has arisen in a number of earlier cases. This arises where the court finds itself simply unable to form a decided conclusion on the evidence before it, and is therefore unable to say who has the better argument. And then in paragraph 80, the Lord Justice said, what does the judge then do? And explains that the solution, this is at E, the solution encapsulated in Lim 3 addresses this situation. To an extent, it moves away from a relative test and in its place introduces a test combining good arguable case and plausibility of evidence. This is a more flexible test, which is not necessarily conditional upon relative merits. And if one goes to 639, very briefly one sees how the position was summed up by Mr. Davis, 119, paragraph 119. I mean, something of a fog is the difference between an explication and a gloss, but whatever the niceties of language involved, it's sufficiently clear that the ultimate test is one of good arguable case. For that purpose, however, a court may perfectly properly apply the yardstick of having the better of the argument. The additional much can now safely be consigned to the outer darkness. That overall confers, in my opinion, a desirable degree of flexibility in the evaluation of the court. Desirable just because the standard is, for the purposes of the evidential analysis in each case, between proof on the balance of probabilities, which is not the test, and the mere raising of an issue, which is not the test either. Now, our position, as the court has heard, is that whilst Brownley and Goldman Sachs and Cahill were all jurisdiction cases, it was never intended for observations made in that context to be kept siloed from the freezing injunction context, and we see that very clearly in the next case, which is Lakatamia Shipping and Morimoto. That's at tab 30 of the authorities bundle. It's volume 3 in the 4-volume version. On page 641, one gathers from what's said at J in the head note that although the primary appeal concerned real risk of dissipation, there was a respondent's notice in which good arguable case was contested, and so the discussion of good arguable case was directed both at real risk of dissipation and the merits. And if one goes then to page 650, the middle of the page above E, the law, Lord Justice Haddon Cave says the basic legal principles for the grant of a WFO are well known, uncontroversial, and hardly need restating. My learned friends seek to make something of that, saying it's hardly the introduction one would expect to see if the court were about to radically change the law. There are 2 points just to flag on that. The first is that what's said to be well known and uncontroversial are the basic legal principles. And we say what must be meant there is the 3 things that have to be established on an application for a freezing injunction. That's to say good arguable case, real risk a judgment will go unsatisfied, and just and convenient. The second point is that, as we've seen, it's always been the case in our submission that there's been a degree of cross-pollination between the meaning of good arguable case in those 2 contexts of freezing injunction and jurisdiction. So the court's subsequent reliance on CAFA can hardly be characterised as a radical change in approach. Paragraph 35 on page 651, Lord Justice Haddon Cave said the test for good arguable case in the context of freezing injunctions is not a particularly onerous one. That's true in the sense that the threshold test is not a high one, as described by Mr. Justice Mustall, but as he himself said, that's the start of the analysis. Paragraph 36, applicant doesn't have to establish risk of dissipation on balance of probabilities, good arguable case is sufficient. Paragraph 36, and then just 37, bottom of page 651. Much discussion of the meaning of good arguable case since the Niedersachsen. What Mr. Justice Mustall.
Sorry, did you make a comment on paragraph 35, or were you reading something? When you read paragraph 35, you said something about Mr. Justice Mustall identifying that it wasn't the end of the test. Was that you, or was that?
That was me. Forgive me.
So
not a particularly onerous one, citing G. We accept that that's true in the sense that what Mr. Justice Mustall described as the threshold test isn't a particularly high one, but that's the start of the analysis. One goes back to the point about merits coming back in. Or
Sorry,
indeed,
when you say the start of the analysis, do you mean the start of the analysis historically, or the start of?
The start of the analysis in a particular case. My subsequent qualification was going to be, and all of this is subject to what's happened since the Niedersachsen anyway.
Well, but it says is not particularly onerous. Well, I may have misunderstood your point.
Well, I mean, Lord Justice Haddon Cave says what he says, and he says there that the test is not a particularly onerous one. He then goes on to...
As I understood it, you said he's right about that because he's applying what Mr. Justice Mustall said in the Niedersachsen,
well,
which I suspect is what we find in Mr. G's work.
Well, it's what we find in G. The paragraph in G is the citation and it is after
Yes.
in the freezing injunction context.
So paragraph 35 does appear to be an endorsement of the newly Saxon test.
Well, at least an endorsement of the more general notion that the test is not a particularly onerous one. Well, then goes on to see what Lord Justice Haddon Cave said when further analysing what the test was, when he talks in paragraph 38 about it having been the subject of a comprehensive review in CAFA in the context of jurisdictional gateways, and he gives a brief summary of what Lord Justice Green had said there, and says that the central concept at the heart of the test was a plausible evidential basis, and refers to paragraphs 73 to 80. We say with respect, that's an explicit statement by Lord Justice Haddon Cave, that what was said in CAFA about the meaning of the phrase good arguable case was applicable in the freezing injunction context.
Except that he seems to think that what CAFA was saying is that plausible evidential basis was really the threshold for the whole test.
Well, except that he refers...
Which was being identified in CAFA.
Well, except that he refers there to paragraph, just at C, paragraph 73 to 80, and those paragraphs address all three limbs of Brownley, not just the objective limb 3.
They do, but when at the end of 37, Lord Justice Haddon Cave says the central concept at the heart of the test is plausible evidential basis. What he seems to be taking from CAFA, which you would say is wrong, is that really plausible evidential basis is the test, not just at limb 3, but at limbs 1 and 2. It's only really in that way one can reconcile that with what he says about paragraph 35 about the test not being a particularly onerous one.
Well, save that plausible evidential basis is mentioned in limb 1 as well. So it runs through, we would say it runs through Brownley in its entirety.
That's true.
So it may be that it's in that sense that Lord Justice Haddon Cave is saying that that's what the central concept at the heart of the test is, because one sees it both at the limb 1 and 2 stage and in the objective limb 3 stage.
All right.
And that approach has been followed in a number of first instance decisions. I think given the time, perhaps the most convenient thing, subject for the court, is for me to flag some of the relevant references. The first is to Bank, Finance and Credit in Trivago, a decision of my Lord the Chancellor. That's at tab 35, beginning at page 706, and there's a reference in paragraph 170 on page 750 to the test of whether a claimant has shown a good arguable case for the purposes of a freezing injunction, having recently been confirmed in Nakatamia and Morimoto. There's a decision, forgive me, of Mr. Justice Edwin Johnson in Harrington and Charles Training and Mater. That's at tab 39. The discussion of good arguable case begins at paragraph 243 on page 260. There's a reference to the test of good arguable case having recently moved on, or having been suggested that was the case, in paragraph 248 at page 962. Reference on page 965, paragraph 252 to 253 to Nakatamia and Morimoto and its adoption in Bank, Finance and Credit. And then at paragraph 254, Mr. Justice Edwin Johnson said the claimants contended it was wrong to conflate the test for good arguable case in the freezing injunction context with the test for good arguable case in the jurisdictional context. So far as good arguable case is concerned, however, both Lord Justice Haddon Cave in Nakatamia and the Chancellor in PG.SC, that's Bank, Finance and Credit, do not appear to draw this distinction, at least in the context of showing a good arguable case in relation to the question of risk of dissipation. It's not right to say, in my respectful submission, that the discussion of good arguable case in Nakatamia and Morimoto was confined to real risk of dissipation. We say that the court's comments in that case were also directed to the merits thresholds, as it seems were my Lord the Chancellor's remarks in Bank Finance and Credit and Zhivago. And still in that paragraph on page 965, Justice Edwin Johnson said it may be that any such distinction derives from the fact that the test of good arguable case in the context of jurisdiction had come to engage the concept of having much the better of the argument, whereas now the use of the word much in this formulation of the test of good arguable case has been discredited in the jurisdictional context. We say that that is indeed part of the reason why it seems the better, or much the better of the argument test wasn't universally adopted in the freezing injunction context. The other being the outstanding question of what to do if the court couldn't decide who had the better of the argument. But those issues with the test have since been overtaken. And so it was paragraph 255, Mr. Justice Edwin Johnson said, where does all this leave the test of good arguable case? I accept the law's moved on from a simple 50% test of good arguable case. Seems to me that in applying the test of good arguable case, I should take account of the analysis of Lord Justice Green and Kafer and the three-limb test as reformulated by Lord Sumption in Goldman Sachs. Another first instance decision where that approach was adopted is Chowguler and Shirk. That's at tab 41. And perhaps I can just give reference to paragraphs 43 to 45, paragraph 46, where Mrs. Justice Dias explains the approach that she was taking. But it's right to say that in many cases, judges have continued simply to apply the old Niedersachsen interpretation, perhaps in part because that's the interpretation that appears in the textbooks, and one sees that shortly before judgment was delivered in this case, Mr. Justice Butcher handed down his judgment in Mahomadov. That was a notification injunction case which addressed this conflict in the authorities, and that's at tab 42. And beginning at page 1101, Mr. Justice Butcher set out under the heading legal principle 2 points which he said required expansion. One related to the test of good arguable case on the merits. He identified paragraph 15 2 cases on which he sought submissions, and then he discusses Harrington and Later and Chowguler and Shirk. We can pick up his conclusions on page 1107. Paragraph 21, after careful deliberation but without real doubt, he thought that Harrington and Mater and Chowguler and Shirk were wrong in applying the three-limb test applied from Brownley. Paragraph 22, the Niedersachsen test is long established, has been applied very frequently, has been called the traditional test. And then goes on to refer to Kazakhstan, Kagazi, and Hollyoak in paragraphs 22 through to 25. And in 26, he says, in none of Brownley, Goldman Sachs, and Kafer was it suggested that the approach to the jurisdictional gateway question also applied or should apply in the context of freezing orders. And then in paragraph 27, he gives his reasons for saying why the threefold test applied in those cases shouldn't be applied in the context of freezing injunctions. Just picking up some of those points. Paragraph 25, no reason why the test should be applied. The jurisdictional test should be applied as the merits test in relation to freezing injunctions is directed to a different end. That doesn't address the fact that there may be other reasons why a test that was originally developed in one context might also be appropriate in another, and I'll come back to that, as I said I would, in dealing with matters of principle in a moment. It's not surprising, paragraph 26, that nothing was said about the application of the test in the context of freezing orders in Brownley, Goldman Sachs on Kafer. Hardly surprising because the court wasn't considering that question in those cases. And in relation to what's said in paragraph 27 about there being good reasons for not applying the three-point test, so the making of such a relevant assessment is liable to draw the parties and the court into the conduct of mini-trials. A relative assessment encourages the parties to bring forward at this early stage every piece of evidence which might suggest they have the better of the argument. This is likely to lead to more of the court's resources being absorbed in interlocutory hearings, brought on very often on an urgent basis. This is deprecated in the authorities and will place an even greater burden on the court. With all due respect, we would say that's not a point which takes matters further forward, because the imperative to avoid mini-trials is just as strong, if not stronger, in the jurisdictional context, and yet the Supreme Court has found that the Brownley test or interpretation is appropriate there. So we say that doesn't provide a reason as to why it shouldn't be appropriate here. Then he goes on to say...
Yes, and as a consequence of that, both the Business and Property Courts at first instance and the Court of Appeal are actually infested with continuing jurisdiction disputes where people are arguing the toss about the merits of matters in a way in which it was never intended.
But there is this critical difference, isn't there? In the jurisdiction context, where what is one is concerned with is whether you come within the gateway, then you can and often are dealing with a matter which is not going to be revisited, and therefore you're not in that case conducting a mini trial in relation to something which is going to be revisited at trial. You are trying to decide whether it's right that the defendant should have to come to this court in the first place to be subjected to the process. By contrast, in the freezing order context, one is concerned with whether you have a mini trial at the interlocutory stage of the merits of the case, which are going to be the subject matter of a trial.
I'd accept that, but equally there are, of course, circumstances in which issues are considered in the context of jurisdiction, which then arise again at trial.
They can do, but
They can do.
that's happenstance, isn't it? As a
Yeah, it's happenstance.
general point, the jurisdiction issues are going to be specific and not revisited.
My lady,
And the test must surely recognise that.
my lady, I accept that would be the norm. That those issues on jurisdiction would be dealt with once and for all.
As I see it, the real thrust of what Mr. Justice Butcher says, picking up as he does on what Mr. G says in his book, paragraph 29 of the judgment, is the point about the time when applications for freezing injunctions are made, which is they're made at the outset, particularly in fraud cases, in limited information before disclosure. And he's making the point that if you apply the jurisdiction, the higher, as it were, a higher test, then you run the risk of people not obtaining freezing injunctions when it would be just that they should do so. And he also picks up at the end of 27 on, I read him there as saying really that the cyanamide test is effectively, or should be effectively, the same test, serious issue to be tried. It's a low threshold.
What he's saying at the end of 27 is that there's a gap between the merits tests in the proprietary injunction context and in the freezing order context, and following Brownley would widen that gap. But there are good reasons for there being that gap, because in the context of a proprietary injunction, what's being sought is a restraint on the use of a specific asset that's alleged to belong beneficially to the claimant. In the context of a freezing order, the court's placing restrictions on a defendant's ability to deal with its own assets, and not just a specific asset, but all its assets up to a given value. We say that's a greater invasion of the claimant's rights and therefore justifies a higher test. So it's not surprising that there should be, and indeed there should be, a gap between the test in a proprietary injunction context and a freezing order context. I'd also make this point, and I'm acutely aware of what your lordship has adverted to in terms of the strains on the courts, but in my respectful submission, it's rather unrealistic to think that in the context of an application for a freezing injunction, typically made in heavy commercial litigation, generally involving allegations of fraud and dishonesty, that parties aren't already going to be bringing forward their cases to the fullest extent that they can in the context of a freezing injunction, whether the test is good arguable case in the Niedersachsen sense or good arguable case in the Brownley sense.
Well, it's not my experience when not infrequently as defendants who come along on return day and say we vehemently deny all these allegations, but we recognise that we're not going to be able to challenge the evidence on the interlocutory basis if all that is required is the Niedersachsen test, and therefore we'll fight it on another basis or we'll give an undertaking. It's not my experience that defendants inevitably have a go on the merits in every case. They don't.
Well, my lord, I'm not suggesting that, but equally, one can easily see a defendant taking a view in circumstances where the third limb of Brownley, plausible evidential basis, viewed objectively, might similarly lead them to take a view, so to speak, in terms of not resisting making a freezing order.
What Mr. Butcher goes on to say at 34, in effect he equates that plausible evidential basis with the Niedersachsen test, it seems to me. I think that's a point my lord was really putting to you earlier on in relation to what Mr. Justice Haddon Cave said. Query whether he was really saying anything different. And wasn't really saying that, as it were, the whole of the Brownley test becomes incorporated into freezing injunctions. What Mr. Justice Butcher is saying here is, well, the Niedersachsen test is really reflected in plausible evidential basis. In other words, whether a disputed question is a fact case will not be more than barely arguable if there is no plausible evidential basis for it. So it's effectively equating the two.
Yes, but Lord Justice Haddon Cave, as we saw, referred to CAFA paragraph 73 to 80, which encompasses all the limbs of the Brownley test. So one can't, in my respectful submission, simply hive off limb 3 and say that that's really all it boils down to. That's not in my submission what Lord Justice Haddon Cave was saying. Right.
So that's that. That's the end of the line of authorities until you get to this case, isn't it?
Until we get to this case, and essentially, the judge's analysis involved trying to work out what Lord Justice Haddon Cave thought he was endorsing in Lakatamia. He concluded that Lord Justice Haddon Cave hadn't intended to depart from the Niedersachsen. And if one then goes, so this is in the, forgive me, in the core bundle at tab 8. So the analysis begins at paragraph 34, essentially one sees in paragraph 36 that he says it's not at all clear that Lord Justice Haddon Cave intended to have the transformative effect for which Mr. Santos contends. Then he says that paragraph 36, his own views aligned with that of Mr. Justice Butcher. But paragraph 37, he couldn't help but note that the law was in a confused state, crying out for a definitive answer from the Court of Appeal. There is a further case that my learned friends have sought to include called MEX Group. It's at tab 43. I'm not asking you to go there. I hear how my learned friends develop their submissions, but there's no engagement there with the debate. It's simply said that Mohamedov is described as the most recent analysis of the law. So trying to tie those threads together, you see that at the outset, what Lord Denning was referring to, when Lord Denning was referring to in a good arguable case, he was referring to the test set out in Corner. We see that in the Pertamina. In the Niedersachsen, we see how Mr. Justice Mustel interpreted corner. An alternative interpretation was proposed by Lord Justice Waller in Canada Trust, much the better of the argument. That was then approved by the Privy Council, and so we say, strictly speaking, if we're right about the expression having and always having been intended to have the same meaning across the two jurisdictions, that should then have been applied by judges in the freezing injunction context. We've seen some instances where that's what happened. There were two problems with the Canada Trust interpretation which seem to have caused a degree of reluctance to adopt it. The use of the word much, which puts things slightly too high, and what to do in circumstances where the court can't reliably conclude who has the better of the argument. Those were resolved in Brownley and Goldman Sachs, so the claimant doesn't have to have much the better of the argument, and limb 3, the court, if it can't reliably conclude who has the better of the argument, can fall back on there being a plausible, albeit contested evidential basis. So we say what follows from all of that is there's no longer any reason why judges should be reluctant to apply the Brownley and Four Seasons approach. And Lakatamia, we say, states unambiguously that the observations made in Brownley and Goldman Sachs and Kafer apply in the freezing injunction context. I said I'd come back to look at this briefly as a matter of principle, leaving aside the authorities. We respectfully submit that freezing injunctions are now granted very often, one might almost say routinely, in the Chancellor Division of the Commercial Court, and so it can be easy to become inured to them. But if one steps back and thinks about it, they're obviously a very invasive form of relief, stopping someone from dealing with his own property, typically all of his property up to a certain value and often for a number of years. One's familiar with what Mr. Justice Donaldson said in Bank Mellat about freezing injunctions being a draconian remedy in one of the law's nuclear weapons.
Well, is that really still an appropriate description?
Well, my Lord,
Something that's detonated hundreds of times a year.
well, my Lord, as I said, one sees freezing injunctions granted almost routinely, and we say that does give rise to a real issue in terms of the intrusiveness or invasiveness of
Well,
the
I
freezing
understand that,
injunction.
but there are quite a number of moving parts, only one of which is the merits test. There's the various provisos in relation to ordinary course of business or personal living allowances. There's the cross-undertaking in damages, which can be fortified, and there may well be scope for merits to come in at the third stage of whether it's just and convenient, which don't form part of the threshold test. There is the element of sufficient evidence of a real risk of dissipation. So there are a whole lot of moving parts which may control the difficulty of getting a freezing order. And you may be right in saying that they're not perhaps always applied with the rigour that the invasiveness of the result might justify. But it isn't necessarily an answer to say, well, you must have a more stringent merits test.
My Lord, I recognise that the prejudice to a party on the receiving end of a freezing order ought to be mitigated to some degree by the exceptions to the order and across undertaking and damages and so forth.
The experience, I think, of most judges, most first instance judges who granted these injunctions, would be that it's the risk of dissipation that is the real focus, and that's what you're concerned about. And that's a control, as my lord said, that's a controlling mechanism, because obviously, unless there is a real risk of dissipation and it's a genuine case, then the court will not be prepared to grant an injunction, however strong the merits are. So, certainly my own experience, very rarely the case, I can't think of a single case where I was asked to make a freezing injunction, where I declined to do so because I didn't think that the needed asks and tests were satisfied on the merits of the claim, but I can certainly think of cases where I refused to grant an injunction because I wasn't satisfied there was a real risk of dissipation. I think that would probably be reflected in most judges' experience, both in the Commercial Court and in the Chancery Division. So,
My lord,
anyway, sorry, we're taking you out of.
not at all, my lord, but my respectful submission is that where one has what is, notwithstanding the possibility of it being mitigated to some degree by ordinary course of business and living expenses, exceptions and cross-undertaking and so on, one has what is a highly intrusive form of interim remedy, generally, in fact, invariably accompanied by invasive disclosure orders, all being potentially pleased at the instance of a hostile counterparty. And of course, the reason for granting a freezing injunction is to ensure that any judgment that's eventually given in the claimant's favour isn't rendered futile. The less likely it is that such a judgment will ever materialise, the less justifiable, in my respectful submission, that kind of invasive relief should be. So the question is, well, where should the court draw the line? And we say the obvious answer is that if the court can reliably conclude, based on the evidence available at that stage, that the claimant is more likely to win than not, then granting that sort of invasive relief may be justified. If the court can reliably conclude that the claimant is not more likely to win than not, based on the evidence available, the defendant seems more likely to lose and therefore never to get the judgment that the freezing injunction is intended to protect, then in our respectful submission, the court can't be justified in granting such intrusive relief. And that, of course, is the approach embodied in Limb 1 of the Brownley interpretation. There's obviously a difficulty when the court can't reliably conclude who's more likely to win. What should it do then? One approach would be to say, well, there should be no injunction issuing, but that, of course, risks leaving claimants without protection, which may ultimately prove to have been required because of the confines of the interlocutory process at that stage. So what one needs is a minimum threshold which reflects the gravity of the relief but isn't unduly onerous, and we say that's what Limb 3 of Brownley provides with its notion of a plausible, albeit contested, evidential basis.
So
That
that's-
can't, sorry, forgive me.
That's an articulation of a justification which does not itself draw any relevant analogy with establishing a gateway for jurisdiction cases. It just adopts the same standard because it is a standard which is higher than serious issue to be tried. Is that a fair way of characterising it?
My lord, yes.
I mean, when I asked you earlier, what would your retort to have been to Lord Justice Longmore and Mr. Justice Butcher saying there's no reason for the test being the same in a jurisdiction case? Your answer is, well, there's no reason specifically why it should be the same because one is in a jurisdiction context, but it is just a higher standard than serious issue to be tried, and that is justified by the invasive nature of the relief. Is that essentially the point?
I know that's fair. And if one goes back to the pertinent, one sees how it is that there was borrowed or imported from the jurisdiction context a test which was considered to be appropriate in the freezing injunction context, and then of course there have been considerations of that in numerous authorities as we've seen. But the fact that good arguable case test is considered appropriate in the jurisdiction context for one reason or set of reasons doesn't mean that it's not appropriate in a different context. But our justification or our proposed justification for it is predominantly by reference to the nature of the relief, the seriousness of the relief that's involved, rather than saying that it follows as a matter of logic that one should borrow something from the jurisdictional context.
If one were applying logic, you would apply the merits test from jurisdictional cases, which is serious issue to be tried, not the gateway test.
But that's never, I think, been posited in any of the authorities that we've seen. One's been concerned with good arguable case, whatever that means.
Well, that is true, but something that has occurred to me is that the Niedersachsen test may not actually be very different or different at all from serious issue to be tried, as that latter test has itself evolved in the context of summary judgment, because in the summary judgment context, and as then further applied to amendments and to the merits test in jurisdiction cases, it means more than arguable and carrying some degree of conviction. One sees that in a number of cases, including Court of Appeal cases. Is there really any difference between Niedersachsen, more than barely capable of serious argument, and more than arguable and carrying a degree of conviction?
Instinctively, if I may talk that way, those two tests have quite a different feel to them. Serious degree of conviction is suggestive of something considerably more rigorous.
No, the degree of conviction is the summary judgment test, but not serious degree of conviction. Niedersachsen is more than, i.e. the threshold, barely capable of serious argument.
I'm not sure that this is an answer to your lordship's question, but if one accepts for the sake of argument, and given your lordship's observations, I'm not sure that it's safe to accept this for the sake of argument. If one accepts that a freezing order is a serious and intrusive remedy, then setting the bar as low as the Niedersachsen appears to, when one goes back and look at what's the glosses on more than barely capable of serious argument, competent counsel can sort of get a case off the ground. That does, in my submission, represent, on the face of it, a very low threshold for the grant of such intrusive relief. I'm not sure that's an answer to your lordship's question, but
Can I, well, whilst I've diverted you, just explore something else, which is that an ordinary cyanamide injunction can have very invasive consequences, more invasive perhaps than some freezing orders. And yet the test in those circumstances is serious issue to be tried. An interlocutory injunction which prevents someone from engaging in particular conduct, maybe conduct by which they earn their living, competition cases, so on. And those are very intrusive consequences.
sorry, forgive me.
And the invasiveness of the consequences is taken into account at the just and convenient stage, but not by imposing the high merits threshold. Because, as I understand it, what the merits threshold is there to achieve is you've got to at least get as far as saying, I've got a case which is sufficiently strong to go to trial. And once you've got to that stage, then you look at what's just and convenient by reference to the nature of the relief that you're seeking, and that's why you have serious issue to be tried, which is the same as the merits test for summary judgment. It's the merits test for a cyanamide injunction, and it's the merits test for a jurisdiction case as a threshold.
My lord, I'd suggest that what happens in practice in terms of what I would call a particularly invasive cyanamide injunction is perhaps a greater focus on the balance of convenience than one might see in a typical freezing order case. And so to the extent that the merits threshold is lower, the heightened focus on balance of convenience mitigates that to some degree, I'd suggest.
I think you're right in practice, but it may be that in freezing order cases there ought to be more differentiation between different cases. But we're all familiar that there are some that all have a pattern, but equally one gets freezing order cases where it's reasonably clear that the defendant only has one or two or three assets. It's not one of those cases where they're hiding assets, and one can see what the particular effect will be for that particular defendant of the freezing relief. I'm just exploring really whether conceptually a merits threshold is the right tool by which to regulate recourse to the invasive consequences, or whether merits and other factors are a way of regulating it at the just and convenient stage.
My lord, when your lordship says merits and other factors, I mean, clearly we would say that a very careful scrutiny of the merits ought to be a crucial and necessary part of that exercise, and that should be undertaken by reference to a threshold which is not set too low. I think, my lord, the Chancellor mentioned earlier that he recall freezing injunctions being denied on the basis that real risk of dissipation wasn't made out, but couldn't, if I remember correctly, sort of call to mind instances where the merits threshold hasn't been met. With the greatest of respect, that gives rise to some concern and might be thought in itself suggestive that the bar has been taken to be set rather lower than where it should have been. Can I just turn for a moment?
Yes, and maybe you want to come back on these. I've thrown out some, and it's right to say that, I mean, not even Mr. Justice Butcher went as far as suggesting that the test should be equated.
It was quite close to it.
But he did regard there as a gap which shouldn't be widened, although he is quite close to it.
Well,
But,
the gap that shouldn't be widened with respect was between specifically proprietary injunctions, where American cyanamide was the test, as opposed to American cyanamide tests.
well, there is a subsequent paragraph, I think, in which he goes on to recognise that I think the test is higher. But
Anyway,
anyway,
I think we should move on.
yes,
Well, I think given where we are in terms of timing, it's probably time, if I may, for me to sit down and hand over to Mr. Olive Cooper, because I'm concerned that we've got two further issues to get through.
Well, the position is that we cannot sit beyond 4:30. Simple as that. Speaking for myself, I'm not available tomorrow. So
I'll shut up.
I think all the more important for me to hand over to
I mean, maybe we can shorten the lunch break if the staff can provide somebody who's, I'm conscious of whittling away at people's lunch breaks, but it's possible we might be able to reduce the lunch break to 15 minutes or something.
The only other
Anyway,
thing,
let's get on with the other issue, shall we?
my lord, the only other thing that occurs to me in those circumstances is whether, and I'm very hesitant to raise this, whether we should aim to deal with all the freezing injunction points in relation to good arguable case and the facts and evidence, and then once you've heard argument from us on that, see if we can wrap up the costs separately in case there isn't time to wrap up the costs today, because there's quite a lot of authority in relation to that as well, and obviously quite a lot at stake. I just wonder, just trying to be practical about it, and seeking the court's indulgence, whether that might be a practical way forward.
That seems sensible.
I'm very grateful.
Let's do that, and then at least we get the freezing injunction.
I'm grateful.
And if need be, we can deal with costs on written submissions. Okay. Yes, Mr.
My lords, my lady, I want to make clear at the outset that the arguments that I'm about to present, we say, show that Unitel doesn't have a good arguable case, no matter how the threshold is construed, or indeed whether their merits are to be properly taken into account with greater weight at the discretionary stage. So the arguments that I'm going to make in Route A are a complete answer to the freezing injunction, regardless of the legal conclusions that we've reached on the points raised by my learned leader. It's common ground between the parties that Unitel's claim is governed by Angolan law. If we start then at tab 48 of the authorities bundle, page 1162. 1162, tab 48. This is the Angolan Commercial Companies Law, and if you go over the page, there's a chapter 7, that is on civil liability for incorporation, management and oversight of companies. One of the articles within that chapter is Article 80. And if I could draw the court's attention to Article 80, subparagraph 1, the company can only file an indemnity action, which includes the current action, after a shareholder resolution is passed on it, and it must be filed within a period of 6 months, counting from the date of the approval of said resolution. As we'll see when we go through the expert evidence, failure to comply with that provision renders a claim forfeit, and I'll take you to what that expression means. But the key point in this case is that this article has not been complied with. So if I take you to the supplemental bundle, tab 6, page 37. This is a resolution approving the claim against Mr. Santos. It's dated the 4th of March, or the 4th day of March, 2022. Unitel's case that in fact this is a clerical error and the correct date is the 6th of April 2022. We're not going to ask the court to get into that debate today, and so for present purposes you can assume that resolution was indeed passed on the 6th of April 2022.
Page 37.
Page 37 of the supplemental.
Yep.
Yes. So I take you to this just because it's the...
What's the correct date?
The correct date is supposedly the 6th of April 2022.
6th of April.
I mean, that will be in contest, but for the purposes of today, it can be taken as the 6th of April 2022. So the essential point is this. The shareholders' resolution was, it said, passed on the 6th of April 2022. Unitel was therefore obliged under Article 80 to commence proceedings against Mr. Santos by the 6th of October 2022. It didn't do that. The amended claim form and particulars of claim were filed and served on the 1st of June 2023, and so Unitel's claim is forfeit. Unitel's response to this is to say, well, no, actually, in order to comply with Article 80, it was sufficient to apply for permission to bring a claim against Mr. Santos, which they did on the 3rd of October 2022, so 3 days before the 6-month time expired. Now, Mr. Justice Bright held that Unitel had a good arguable case on that point at first instance. We say that is manifestly wrong, and when I take you through the expert evidence, I'll show you why it's wrong. So in terms of structure, I'm going to go through each of the expert reports in chronological order. That, as I say, will enable me to explain why Unitel's argument as to what is sufficient for the purposes of Article 80 is indeed wrong. And then I will briefly, if there's time, take you to the judgment so you can see how the judge dealt with this question. And then, if I can, I'll wrap up with the periphery debates about the Limitation Act and Section 35, but I'll do that last. Okay. So, my lords, my lady, in terms of how the first expert report came about, you recall from my learned leader's very brief introduction that the current proceedings were brought initially against UIH only, and then it was only on the 3rd of October 2022 that Unitel applied for permission to join Mr. Santos to those proceedings and to amend its statements of case to make a claim against her for breach of her duties under Angolan law. That application was supported by an expert report from Professor Dario Vicente, who has worked with Unitel on other cases. And if we start with that, it's at tab 8, page 55 of the supplemental bundle. And just on the front page, I'd ask the court to note that this report was prepared in July 2022, so long before the 6-month period had expired. I'll come back to the relevance of that. Page 63 in the supplemental bundle, please. Subparagraph F, this may be important. There's a point about the interrelationship between Angolan and Portuguese law. The long and short of it is that Angolan law is based on Portuguese law. Indeed, sometimes the statutes are literally identical, and as a result, Angolan jurists will rely upon Portuguese authorities and refer to Portuguese authors, etc. If we then go directly to what is said about Article 80, which is on page 80, paragraph 80. I'll just take you through it. So Professor Vicente says that a claim against Mr. Santos would be available under a particular provision of the Angolan Companies Act. And then at paragraph 81, he says the claim against a director must, however, be the object of a resolution of the shareholders, and the time limit to submit it, then there's a bit of an infelicity in the language, is of 6 months. But can I just emphasize at the outset, the it there, the time limit to submit it, is the claim against the director. And there's a reference there to Article 80. Paragraph 82, he says this is a forfeiture period, the course of which can only be prevented, according to a particular article of the Angolan Civil Code, by performing within the legal period the act which the law assigns an impeding effect. And then a key paragraph in our submission is paragraph 83. For this purpose, Unitel must commence judicial proceedings before the competent court, and I emphasize this, claiming compensation against its director in the terms approved in the shareholders' resolution. And then he says in paragraph 84, according to the Portuguese Supreme Court, the lodging of the required application of the court registry is the act that prevents the forfeiture of the right to commence proceedings. There's then a footnote, and that footnote refers to a decision of the Portuguese Supreme Court from April 2017. I'll take you to that very briefly. Tab 7, page 42 of the supplemental bundle. And in the interest of time, I'll just take you to the relevant passage. It's on page 51. And it's the very top of the page. What in this regard we can affirm is that the entry of the petition in the registry prevents the expiration of the forfeiture period. And then the court refers to the same article referred to by Professor Vicente, Article 333. And just to be clear here, the petition in this context was a claim. It was a claim based on a car having been defective. It wasn't an application for joinder or anything like that. Just for your note, actually, I'd encourage the court to read this judgment in its own time, but page 49, there's a reference there to what the nature of the claim was and why forfeiture arose in that context. So if we go back to page 80 of the supplemental bundle and Professor Vicente's report, we were on paragraph 84. If we go on to paragraph 85, there's a reference there to limitation periods, which are a separate concept under Angolan law, as I'll go on to explain. And if you go over the page and skip forward to paragraph 87, the limitation period operates concurrently with the above-mentioned forfeiture period, i.e. the right to damages must be enforced within 5 years, and then at Roman 2, within that time frame, the company should obtain shareholder resolution for the claim, and then I emphasize this again, commence proceedings within the subsequent 6 months. So at this stage, Professor Vicente is clear that what is required is A, a shareholder's resolution approving the claim against the director, and B, the commencing of judicial proceedings claiming compensation against that director within 6 months of that resolution. Now, my lords, my lady, at the time that this report was written, a shareholder's resolution had in fact already been passed, but you won't find that mentioned anywhere in Professor Vicente's report, even when he comes to apply the law to the facts. And in fact, it's not in the bundle, but I can tell you, there was no mention of the fact that the resolution had already been passed in any of the claimant's evidence either in the joinder application or in the worldwide freezing order application, which was issued at the same time. The only thing that we have is, if you go to page 60 of the supplemental bundle, this is a list of documents that was provided to Professor Vicente for the purpose of preparing his report. And if you look at subparagraph F, those minutes are in fact, we now know, the minutes containing the resolution approving the claim against Mr. Santos. But that obviously is not apparent from subparagraph F, and we weren't provided with these documents at the time. So the upshot of that was that at the time that the amendment and joinder application was heard, we had absolutely no idea that a shareholders' resolution had even been passed. We thought they were planning to pass one once they got permission. And the result was that Article 80 didn't even come up in the context of the amendment and joinder application. That application, as my learned friend said, was granted, save for one aspect of Unitel's claim, an aspect of unjust enrichment. We then appealed against that and turned to preparing our defence. And it was in the context of that exercise that we asked for the documents that were mentioned in Professor Vicente's report, and then we discovered that, actually, after all, a resolution had already been passed. And not only had it already been passed, it had been passed so long ago that under Article 80, Mr. Santos' Unitel's claim was forfeit, and in fact had been since before the amendment and joinder application had even been heard. So we wrote to Unitel saying, how come this point wasn't raised? And what you might have thought is if Unitel really believed that applying for permission was sufficient for the purposes of Article 80, they would have written back immediately to us and said exactly that. There's nothing to see here. But in fact, they didn't respond to us for 11 days, despite chasing. And we say that's quite telling. They had no ready answer to this point. And in that intervening time, we applied for permission to admit this argument into the context of our appeal. And for those purposes, we prepared our own expert report. So I'll take you to that. Tab 9, page 95 of the supplemental bundle. This is the report of Professor Ribeiro. I say Ribeiro. If you go forward to page 97, paragraph 5, this sets out Professor Ribeiro's qualifications. She's a teacher of company law in Portugal at the master's level, amongst other qualifications. My learned friend, I draw your attention to this because my learned friend says in his skeleton that she has no Angolan law experience, but as I took you to, Professor Vicente himself says that Angolan jurists will draw upon Portuguese jurists and authors, and so there's really nothing in that point. In terms of the substance, if we go over the page to page 98, it's a very short report. Paragraph 9, Professor Ribeiro says that as set out in the report of Professor Vicente, a claim for damages against a director is subject to strict forfeiture rules. And then all she does is just agree with Professor Vicente. She says that he correctly describes the applicable forfeiture period, and then she summarises that. A claim for damages against a company's director must be the object of a resolution. Paragraph 10.2, the claim must be submitted within 6 months of the shareholder's resolution. Paragraph 10.3, the 6-month period within which the company must bring their claim is a forfeiture period. As a result, the only way to prevent the passage of the forfeiture period is to perform within the legal period the act the law assigns an impeding effect. And then again at paragraph 10.4, in a case such as this, therefore, Unitel must commence judicial proceedings before the competent court within 6 months of the relevant shareholder's resolution. And then I said I would explore what the consequences of forfeiture are. This is covered at this stage in Professor Ribeiro's report. Paragraph 11. The expiration of the forfeiture period has the automatic legal effect of extinguishing the claimant's right, i.e. the right of the company to file the claim for damages against the directors, proved in the shareholder's resolution. That's extinguished. In the present context, that would mean that a claimant company would lose its right to file a claim for damages against the directors. if the commencement took place outside of the forfeiture period. And then, I think it's now over the page, paragraph 12. If the company loses the right to file a claim against the directors, the consequence for any action brought by the company after the forfeiture period expires that the defendant will be acquitted, i.e. the claim against them will be dismissed. So everything is going to, if we're right on forfeiture, that's the end of Unitel's claim. So essentially what we have at this point in time is two experts saying that the company has to commence judicial proceedings claiming against the director within 6 months of the resolution. Otherwise, Unitel's claim is forfeit and forcibly dismissed. Now, for Unitel, this is obviously a disaster. It's the end of its claim. And I'm afraid that what happened in response to this was that Professor Vicente changed his evidence. And so I'm going to take you to that evidence now. It's tab 10, page 101 of the supplemental bundle. And the relevant passages start on page 107. Paragraph 70 begins by reciting Article 80, that's the same wording that's in the bundle which I've shown you. Paragraph 8, he says, as stated in my first expert report, the 6-month time limit provided for this rule is a forfeiture period within which a commercial company must file an action, or, as will be explained in further detail below in this report, carry out before the competent court another procedural act whereby that company exercises, pursuant to the relevant article of the Angolan Companies Law, its right to claim from a director or former director compensation for damages. So immediately we see Professor Vicente qualifying his previous evidence by saying that actually something other than filing an action can suffice for the purposes of Article 80. Although note that this something must still involve the company exercising its right to claim from the director. Paragraph 9, he says that this is a forfeiture period, which is different to a limitation period. Again, we'll come back to that. And then paragraph over the page, paragraph 11. In general terms, while limitation periods, which are usually longer, operate as a sanction against the inertia of the right holder in exercising it, forfeiture periods, which are usually shorter, are essentially dictated, as will be shown in greater detail, and these are the policy considerations underlying this, by reasons of legal security and certainty, namely the need to avoid situations remaining undefined for a long time. So this is really important. This is really important. The point of a forfeiture period is to avoid situations remaining undefined for a long time. If we go on to paragraph 15, he agrees with Professor Riviero on the consequences of failing to comply with a forfeiture period, which is the extinction of the relevant right. And then over the page, onto paragraph 16, he says, in order to understand the significance of said rule and to determine under what circumstances the expiry of said forfeiture period may occur, it's essential to consider its purposes. He's actually already set those out once, but he sets them out again now in slightly different terms. Paragraph 19, he says, the fulfillment of social need for legal security and certainty as regards subjective rights, and the protection of the interest of the passive party to a subjective right. And a little bit later, he'll give a bit more detail on what that means. So if we then go forward to paragraph 23, according to the wording of Article 80, the relevant procedural step in issue is the filing of the indemnity action. The question arises, however, of what exactly should be understood as such for the purposes of that provision. And then he talks about how proceedings are begun under Angolan law, referring to Article 267. But then in paragraph 27, if we go over the page, he says that obviously in another jurisdiction, Article 267 is not going to apply, and so another procedural act may be sufficient. Clearly, we agree with that. But then he says this, the purposes of Article 80, he says the purposes of Article 80 are satisfied if a company takes a step, if a company takes before a court of the foreign country a different procedural act which expresses its will to recover the loss sustained by it as a consequence of the breach by a director or former director of its statutory or contractual duties. So at first glance, what Professor Vicente appears to be saying, which really would be a radical departure from his first report, is that any act which expresses a will to recover losses from a director would be sufficient for the purposes of Article 80. And in fact, we'll see that this passage seems to have misled the judge somewhat. But it actually, if you read the report in context, is not what he's saying. So first, we have to be clear that an expression of will has to be before a court of a foreign country, and it has to be a procedural act. So it's not merely any expression of will. It has to be something within a judicial context. So, for example, it couldn't just be the instructing of solicitors to do something. And as we'll come on to see when we look at the judge's judgment, that's an example of something which he thought might have been sufficient for the purposes of Article 80. That doesn't comply with what Professor Vicente himself says. But second, and this is the more key point, it's clear from what follows that actually he's referring to a procedural act which is as good as commencing a claim in terms of legal certainty and security. So that's why he was talking about those policy considerations. And in paragraph 28, he asked the rhetorical question, well, would issuing an application for joinder achieve these purposes, i.e. legal certainty and security? And the answer, he says, is yes. Paragraph 29, he says the answer must be an affirmative. But then it's instructive to look at why he says that. This is so essentially because the need for legal certainty and security as regards subjective rights, so that, for example, no doubts may arise as to their existence, and the protection of the interest of the passive party's subjective right, in the premises the interest of the director or former director, and this may be important, against whom such a claim for damages is made by a commercial company, are equally served regardless of whether compensation is sought in proceedings brought independently or by an application for the joinder of a director or former director to pre-existing proceedings to which the director or former director becomes a party. And that, my lords, my lady, I'm afraid is just wrong. And it's important to emphasise that this is not actually a question on which Professor Vicente is qualified to opine. What he's opining on is the legal consequences of an English procedural act. He's not an expert in English legal procedure or its legal consequences, and he's got it wrong. Also, it's not an exercise he should be engaged in at all, because the experts really shouldn't be involved in applying the law to the facts. They should just be stating what the law is. But as this court will know, issuing an application for joinder does not result in the same legal security and certainty as issuing a claim, or, to use the expression used earlier in Professor Vicente's report, avoid situations remaining undefined, for two reasons. The first is that the application could be rejected, in which case the claimant will then have to decide whether or not to make a separate claim, either in this jurisdiction or another jurisdiction. And the second is that the application could be accepted, but then the claimant could decide, well, actually, I don't want to take up the permission I've been given. I'm just going to, I'm not going to issue the claim. So, in fact, if what Professor Vicente said was right, this would result in the opposite of legal certainty. Because the company could, in theory, issue a joinder application, and on his case, or in his argument, that would be enough to stop the clock for the purposes of Article 80. But then, either because the application is rejected or because they just don't decide to take up any permission they're given, no claim is actually issued. In these circumstances, you stopped the clock for the purposes of Article 80, but then you've got all the way until the end of the limitation period, a period of up to 5 years, to actually act on the shareholders' resolution, which Article 80 says you have to act on within 6 months. So that cannot be right. And in fact, if we move on to paragraph 30 in Professor Vicente's report, he says, in sum, what matters for the purposes of Article 80 is that the effect of the procedural act performed by the claimant company be that of putting its director or former director in the position of a respondent in judicial proceedings. And just to be clear, when he's using the word respondent here, he doesn't mean respondent in the way that we would use that term, he means defendant. He means defendant to a claim, respondent to a claim for compensation for damages. And that's clear if you look at it's on the same page, paragraph 28, where he refers to something having to be done in an amended claim, which is allowed for the compensation of that loss. Pardon me. If you look at paragraph 28, the relevant passage in full is the question thus arises of whether this requirement is satisfied not by filing fresh proceedings, but rather by requesting the jointer of the director or former director at stake to pre-existing proceedings, in which an amended claim is allowed for compensation of loss. So the director or former director becomes a respondent in the proceedings. So it's clear there that what's being conjoined is the making of a claim for compensation and becoming a respondent in proceedings. So he's using the word respondent to mean what we would say defendant. So we actually agree with this. The problem is that issuing an application for permission to make a claim doesn't have that effect. Merely applying for permission to make a claim doesn't make somebody a defendant to that claim. So to summarise, my lord, what we have is a clear statement in Professor Vicente's first report that what Unitel needed to do was make a claim within 6 months. That's then agreed by Professor Ribeiro. Unitel then realises that if that's the test, it's absolutely cooked. And so Professor Vicente is obliged to change his evidence and say, no, actually, on reflection, issuing a jointer application is going to be sufficient, provided it's done in time. But the reasoning he gives for that, the reason he says it's sufficient, is based on a proposition of the legal consequences of an English procedural act, a proposition of English law, which he isn't qualified to give, and which is actually just wrong. So, my lords, my lady, I'm about to turn to the next expert report. Looking at the time. Actually, that clock is slightly wrong, I've been reminded, so I'll continue.
Yeah, that clock's about 5 minutes fast, I think.
Yes, so I'll continue. When we received this report, we asked Professor Ribeiro to express her view on what Professor Vicente had said, and that's set out in her supplementary report, which is at tab 11 of the supplementary authorities bundle, page 117.
Yeah.
And if we, the relevant passages actually start at 121. So she starts by talking about how statutes are interpreted. The starting point is the literal interpretation or letter of the law is the limit of interpretation. The literal wording of the statute is the starting point for the interpreter in determining the meaning of the rule, and at the same time represents the outer limit of acceptable interpretations. But simply this means that the interpreter should only accept a meaning that, taking into account other elements, is contained within the boundaries of the normative text. And then we go over to paragraph 13. In the case in point, as seen above, the text of the law is clear. With respect to the forfeiture period, the action to claim compensation for damages from a director or former director caused by the breach of his or her statutory or contractual duties to a company must be filed in court within 6 months of the date of approval of that resolution. The law therefore requires that the filing of the indemnity action takes place during this 6-month period. So the starting, to summarise what's been said so far, the starting point is the literal interpretation of Article 80. The literal interpretation requires the filing of a claim for compensation. And then she asks, well, the question here is whether, the question as proposed in Professor Vicente's report, is whether this literal interpretation should be overridden by other requirements of the elements of, or sort of statutory interpretation. And if we go over the page to paragraph 15, she says, I agree with Professor Vicente when he says that it's essential to consider the ratio legis, the reason for the legislation in this regard. And amongst other specific purposes, I also agree with Professor Vicente that in general the establishment of a forfeiture period aims to ensure the fulfilment of the social need for legal certainty, legal security and certainty as regards subjective rights, as well as the protection of the interests of the passive party to subjective rights. So everyone's agreed on what the policy considerations at play here are. And then she again asks the same question. The question is whether filing an indemnity action serves these policy considerations such that it might be regarded as a justifiable interpretation of filing an indemnity action, even though it actually goes beyond what's expressly written. And so then she says, if we go forward to paragraph 18, she says, these policy considerations can only be maintained if the UK courts, and under the procedural law that applies, the act of filing an application for permission to join a party to an existing action is procedurally equivalent to the filing of an action considering legal certainty and security. So does it fulfill these policy considerations in the same way and to the same extent that filing a claim does? And she says, well, what would have to be the case? What would have to be the features of a joinder application for it to achieve these policy considerations in the same way? Two things. If we starting with legal certainty and security, paragraph 19, she identifies two things that would need to be required. When faced with this request from the company, is the judge obliged to authorize it or accept it? And secondly, once the judge has authorized it, is the action considered to be filed regardless of any express wording or further actions on the part of the company? Or is it still necessary for the company to carry out other volitional acts for the action to be considered filed, its specificity being insufficient, for example, filing an amended claim at court? As she says in paragraph 20, if a joinder application has both of these characteristics, then maybe it would be considered procedurally equivalent to filing a claim and therefore achieve the policy considerations underpinning this area in the same way. But if a joinder application doesn't have those characteristics, then it can't be said to be promoting legal certainty and security in the same way that filing a claim does. So paragraph 21, if the answer is no, if the answer to these questions is in the negative, my opinion is that the interpretation should be declarative, which just means that the literal interpretation should apply. If the judge can refuse the company's request, or when he accepts it, this request is not sufficient in and of itself to give rise to an action for damages, since its existence depends on an express act by the company, then it's precisely legal certainty and security that justifies the existence of a forfeiture period, that also justifies not considering this application to join the director or former director of proceedings to be equivalent. So if it doesn't have these characteristics, it doesn't serve the policy considerations as well as filing a claim and can't be considered sufficient for the purposes of Article 80. That's looking at the legal certainty and security. She then moves on to the second policy consideration that Professor Vicenti identified in his second report, which is the protection of the interests of the passive party. And if you go to paragraph 23, she says, only if, in light of the procedural rules that apply, the director or former director from whom the company intends to obtain compensation for damages becomes a defendant from the moment the above-mentioned request was made, or from the moment the director is notified, can the pursuit of the protection of the interests of the passive party to subjective right be considered to have been fulfilled by this means. Otherwise, it doesn't seem appropriate to consider this interest has been served by the above-mentioned request from the company. So if merely applying for permission to join a person makes them a defendant, then that would be equivalent to filing a claim. But if applying to join them doesn't result in that person becoming a defendant, then it's not procedurally equivalent. It doesn't serve the purposes in this area in the same way as filing a claim does. So Professor Rivero has identified three traits that filing a joinder application would need to have to be procedurally equivalent. We as English lawyers know, but Professor Vicenti does not know, that a joinder application does not have those characteristics. And as a result, filing a joinder application or seeking permission to amend a statement of case to bring a claim against a person is not the same as, does not serve the policy considerations in this area as well as filing a claim, and therefore cannot be considered sufficient for the purposes of Article 80. And just to emphasise, it would have to be the case that a joinder application is procedurally equivalent to filing a claim on every level. Professor Rivero has identified three traits that she considers a joinder application would need to have. Even if this court said, well, actually, I'm not sure that one of those traits really is required, if you're all satisfied that just one of those traits is absent from a joinder application and needs to be present, then that's fatal to Unitel and its claim. My lords, my lady, that may be a convenient moment to break. I'm about to move on to Vicenti 3.
Are we going to be all right if we start at 2?
How much longer do you require?
My lords, I'm about halfway through, I'm afraid.
Half an hour.
If we could abbreviate the lunch break, I think that would be in everyone's interests.
1:45? Mr. Sinclair?
Yes, my lord, I hope I'm not going to be limited in the amount of time I get.
No, you're not going to be limited because if we don't finish, it just have to be adjourned part heard and you'll have to refix it. Because it was put down for 1 day.
Yes.
I mean, I know Lord Justice Arnold said 1 day, but it's always the responsibility of the parties to satisfy themselves that that is an appropriate time limit. And when I first saw Mr. Margolian's skeleton argument, I'm not criticising, but the fact that he was going back to, as it were, square one with moreover injunctions, my first thought was this case will take longer than a day.
Yes,
I
my
know
lord.
we've done a certain amount of interrupting, but by and large, not as much as we sometimes do. Speaking for myself, can't speak for anybody else. So it really was always a 2-day case, frankly. Anyway, there we are. We'll get. I honestly can't sit beyond 4:30 because I have to go to the memorial service in my old head of chambers, which I do not intend to miss. And I can't do tomorrow for personal reasons either. So
Yes, my lord.
very well. So 1:45 in that case.
Court rise in favour.